किशन चंद जैन सर। किशन चंद जैन सर।
Lord,
I have
petition-
if-
Go from left to right so that, then we.
Milord, may I mention? Justice Nagaratna's bench has released 3 matters, Milord, and directed them to be listed before Justice Oak's bench expeditiously before vacation.
After notice or?
Oh, fresh matters, Milord.
I'll
I've made that mentioning, Milord. Please, that quorum has to come. I'm obliged, man. Mr. Balaji and I separately.
We also moved a make sure that.
Lordship, respectfully, I wish to submit.
Balaji's emails are kept together.
I'm obliged, Milord.
Lordship, respectfully, I wish to submit.
One second.
Hello.
There's people before you, 1 second. Yes?
My lords, I had mentioned this matter earlier. My lords gave us date of 5th, that is tomorrow. It was showing in the case status. I am just requesting not to be deleted. It's a court managers association matter. We have filed application
All.
not to be deleted.
Yes.
My Lord, with the Lordship's leave, my Lord Chief Justice, my Lord, I have filed, my Lord, an SLP sent, my Lord, a mail asking for interim bail, my Lord, in a matter of wholly illegal arrest. My Lord may list it at the earliest, my Lord, is the only request.
Yeah.
This is that.
Very grateful.
My lord's diary number 44894. It's a fresh matter, my
It will
lord.
be listed, ma'am, don't worry.
No, my lords, actually there is a contempt pending in the High Court and it is on 7th November.
All.
So,
When was the impugned order passed?
impugned order, this one was 31st August, but
From now in November.
Please, your
I'll
Lordship.
list it, don't worry, I'll list it.
my
Lordship, respectfully, I wish to.
also there.
1 second, ma'am. Just let's go before you, there are 2-3
My
people.
lords, another matter is also there. That was the in
You
44817.
already circulated an email. This is your fresh matter.
Already, sir,
When did you circulate it?
Saturday only
It must have already been listed.
it's not listed.
Saturday, because you're right, because it was a vacation. I'll look at it today and I'll circulate it.
Lordship, I would like to submit.
Your Lordship, this is the writ petition number 462/2020.
Fresh matter,
No, my lord, after notice matter, my lord, this is
I'll deal with it.
Bihar Bridge collapsing matter, my lord.
All right, yes.
My lords, I'm mentioning a fresh matter for listing tomorrow. From the common judgment, my lords, the SLP is already listed tomorrow for admission.
Please tag tomorrow. Yes.
Because it's only not verified. That was the reason, my
All
lords.
right. I'll get whatever you have to do done so that I'll tag it for
My
tomorrow.
lords, objections were removed. Only
all.
we have already mentioned
All right.
to the writ.
Yes, Mr.
My lord, all difficulty is your lordship knows in Bombay High Court during vacation a petition cannot be filed without the prior permission of the court. So my lord, I sought a written the nature prohibition against NCLT, NCLT, and that matter was orders were to be pronounced on 29th, and we are not aware of that. So on 29th we moved an application in the
Has
morning.
the order been pronounced?
Yeah, to be without a matter which was not heard and which is barred by a suit.
Has the order been
My lord,
pronounced?
we sought a prohibition, we filed a petition, and the registry didn't accept it.
Once NCLT pronounces an order, you can challenge it.
No, there's no question.
To the High
No, my lord, the question of NCLT, I never question of going to NCLT doesn't
Okay,
arise at all.
anyway.
No, my lord, all that, my lord,
Nedu-
the issue is,
Mr. Nedumara, circulate an email, I'll deal with it. Yes,
no,
Please, your Lordship,
email has already
I am-
been sent. Email-
I filed,
I'll deal with it.
Lordship, I filed 2 petitions here before this honorable court and regarding meeting of my grandchildren, and they were not heard properly. I have filed writ petition before Allahabad High Court. The submission is that there is no proper provision for joining the court proceedings through video conferencing in Allahabad High Court,
All right.
and there is no provision for mentioning also.
Ma'am, I got the
And
point.
yes,
You got- ma'am,
I have lost my
ma'am,
belonging. Very
ma'am,
difficult, please.
You got the point.
Please.
It's a fresh writ petition
No, writ petition, fresh writ petition
filed before this court or Allahabad High
from
Court?
the Allahabad High Court
But then how?
because the matter pertains to Greater Noida.
Have you filed an SLP in this court?
No, yes, see, it was not, it was in a transfer petition. The court did not give me an opportunity to.
What is
Please.
the proceeding which you want me to list?
No, I want to say no. There should be the streamlined joining the court proceedings to video conferencing in Allahabad High Court
Okay.
should be streamlined, please.
Mani, that's some job.
Please.
My lord, 1 second, my lord. The only that we are seeking the permission to file. That is all. There's no petition can be filed without permission. That's the problem in Bombay High Court. It's not concerning me alone. It's concerning everybody.
Please tell me, do you want me to list a transfer petition and SLP? Just tell me what you want me
No,
to
no, my humble submission that the writ petition which I have filed before Allahabad High Court, I am submitting, there is no provision for mentioning. It becomes very difficult to address the court.
Yes, ma'am. But but you have to bring something before me, some proceeding before me. I can't pick up the phone
No,
and
no.
say, the Chief Justice, please hear ma'am.
No, video conferencing facility should be streamlined before Allahabad High Court. There is no provision for mentioning also,
All right,
please.
you do this. You meet the Registrar Judicial after mentioning is over. आप उनको समझा दीजिए, हाँ?
The matter coming shown in the 6th list.
Can I give this?
All right, yes.
Not to be
You
deleted.
know, I had mentioned the IA in the common cause matter on 21st October. It was to be listed today. My lord said not to be deleted, but it's been deleted.
Lordship, with the Lordship's permission, may I mention a fresh matter?
No, I'm sorry, Lord, it's the only similar order to be passed. Mining is stopped. Only
All
similar
right,
order to be passed.
It'll be allocated. I just told him. Yes.
My lords, may I mention a matter, my first matter, my lords, where the impugned order was passed on 30th October. The matter is, my lords, it's a mutual consent petition where the children were neglected. The petition was moved by the grandfather.
It will be
My lords,
listed immediately. It will be listed immediately. Don't
my lords,
worry. Today's Monday.
my lord, my only submission is the matter was listed on 30th October before the Madras High Court, where the grandfather moved an application. The children were neglected, and the court directed the court, family court, to pass an order of divorce. And today itself is, my lord, that is the urgency. I mean, what I want, my lord, may lords may list it at least on tomorrow, my lords. But the difficulty would be, my lords.
Why do you have to give such a long explanation? I'll list it tomorrow. What's it?
I'm grateful.
There are two fresh
Don't
matters.
give this. Send an email.
There are two fresh matters.
Oh,
Emails.
याद दिला दो. Quick family matter.
Two fresh matters, my lords. One becomes infructuous on Wednesday because the elections are scheduled for Wednesday. The other, the auction is on Wednesday. One, the impugned order is only 3-4 days old, 29th October. It has been both matters plus. One is an election matter, one is an auction matter.
Puneet.
Lord, I'm seeking to mention a matter that concerns the selection and appointment of judicial officers, persons with disability in the Rajasthan Civil Services exam. But the similar matters are there.
Yes, today.
Today, Lord. So
You just wait. Your matter will be called out with that.
the only difference is that, Lord, now the...
That's all right. Just when the matter is called out.
I'll wait.
You'll be here when the matter is called
Yes,
out.
yes.
Baruka?
Malod's Lordship had issued notice on 21st October return for today because there was some urgency.
What is the matter about?
Well, this is about that section 11 reference order being reviewed by the High Court, as a result of which at the fag end of the arbitration...
Just send an email so that we can then see what is
These matters, my lords, I appear for the state. We still need 2 weeks' time, my lords, to file a reply because...
Let them file a reply,
There's an IA also, my lords, for interim relief. There's an IA for interim relief. I had pressed on that day. Lordship had said, I think the urgency it was listed today, my lords.
Because there was being sought for return of the invoked bank guarantee amounts, my lord. That cannot be granted in any case. There is no urgency. 2 weeks.
There's a clear urgency.
Go for 2.
Eventually, this is all by working capital, which will go on for MP at the end of the day, my lords. My lords, we have it on Friday.
Is, I'll just see his email. If there's some urgency, we may list it tomorrow, day after. If there is, you can tell us that, because frankly, I don't recall what the matter is. You can just tell us, be here, you can tell us that.
Highly grateful.
At least they have a feeling that they were heard. They can tell the client that they were heard. Yes.
Lord, grateful, my lord. My lords directed the matter to be listed today. With
fresh matter?
No, my lord. After notice, my lord specifically directed the matter to be listed today. And the notice also was on the interim relief, my lord. I am only requesting.
Which bench is it before?
My lord, same, this honorable.
All right, just send an email. If there's some
Please.
genuine urgency, we'll see.
Please.
If there's some genuine urgency.
My lord, the
Lord,
issue
this
is, my lord, concerning
this is-
everybody. Not my lord, me or my lord, there is no provision for filing. So not concerning me alone, every lawyer, every litigant in Bombay High Court, you cannot file it. And that's the issue, my lord. And your lordship, list my matter tomorrow, my lord, if possible.
Milos, this
Yes.
is my criminal SLP. Milos, the petition was dismissed.
You're mentioning something.
Yes, Milos, mentioning this. Milos, the petition was dismissed by the High Court, bail petition, on 30th October.
Bail petition.
Bail petition. Milos.
On
On 30th October, we
What is
filed
the
on
offense?
31st.
What is the offense?
Milos, it is in under PMLA. Now, Milos, my
It will be listed.
Milos, my petitioner is contesting election, and the election will come to an end on 13th of November.
I'll give you a date before that.
So, Milos, may kindly.
That's all right. You'll get a date. Don't worry, you'll get a date.
Very well, Milos. Great.
Actually, nobody wants the tenure to end, my lords. We all want our matters to be decided by you.
Yes.
May please. May please. Milos, we had, as your lordship
So
said,
there is a preliminary objection in this matter. My lordship grants me this indulgence. My lord.
Certainly.
My lord, and there are two, my lord, but they are interwoven. First is, my lord, that this property in dispute, my lord, had been sold on 19/10/22. Almost 2 years before the notice was issued to Messrs. Rock Hill Realty.
Sale to?
Messrs. Rock Hill Realty.
We will not take down the name, but it's been sold.
It's been sold. The second is, my lord,
My lord, I appear in the other matter. We have sold the subject property, my lord, long back. And that is what is disclosed, my lord, in the written submissions also.
two review
Really
petitions.
speaking, my lord, the stake is now of the transferee.
Before the review was filed or after the review was filed?
after the review was.
The review was, my lord, the judgment is 25th of August 22. And this is where the second objection arises.
So judgment, when is the review filed, Mr.?
The review was filed on 23rd of September 2022. They claim that the property was sold on 19th of October 2022.
Your lordship may just allow me, my lord, because my learned friend may
Yes.
bear me, my lord. One review is filed on 23rd September 22. The other is filed on 27th September 22. But for reasons best known to them, my lords, and obvious, they did not get it registered. They waited for more than 2.5 months and it was registered on 13th of December 22.
Both reviews registered on the same day?
Yes. 13th December 22.
Right.
So much before registration, it had been sold off.
I got the point. We'll have to deal with this.
Yes, then 27th of January 23, the matter was, the tentative list had come out, it was to be listed in January. Then on 27th January 23, they circulated a letter saying that the listing may be held back for 6 weeks to enable filing of documents.
Right.
And then, my lords, the matter was listed, was supposed to be listed in 1st of February 23, not taken up 9th February, not taken up 18th February.
1st of March.
That's okay. Then what happened?
Finally, a notice has been issued on, matter came to be listed and notice was issued on 26th of September 24.
When was that period?
Right.
So submission is that this delay was being caused deliberately, this application documents to be filed because one of the learned judges who had delivered the judgment was about to retire. So when he retires, then the matter comes up and is taken up. Your lordships have in Vedanta taken the view that this procedure adopted by review petitioners is not acceptable. So these are the two things, and therefore, my lord, now in between, my lord, since the limitation prescribed is of 30 days, my lord, the purpose is that the winning party will act on the judgment.
You have a point. We'll hear the other side on that.
Beloved, only one more feature. Beloved, I am in the other connected matter. Only one more feature. Beloved, when the matter was about to be listed, beloved, they wrote a letter to the registry telling the registry to hold back and not list the matter.
That Mr. Dwivedi also told us that
Yes,
because we wanted
beloved,
to file some
I mean, if you are
documents.
playing ducks and drakes, and today, beloved, notice is issued in.
Same point, no? Yes, Mr.
Same point.
Dwivedi has made the point.
Yes.
We'll have to deal with it. You can give us some broad facts and then deal with this point.
Yes,
because
but also because otherwise under the Transfer of Property Act, the rule of lis pendens applies from the day the petition is instituted. So to say that it was registered a month later or a month and a half later makes no difference. You waited till the day I filed the review petition, and within a month thereafter you sold the property. So you admit that the review petition was filed. The review petition is filed on the 23rd of September 2022, and second date you gave was 27th of September 2022. A month after that you sold.
They get notice of the fact that review has been filed.
No.
Yes. So copy is served.
No. When did you serve?
Just, Mr. Call, just don't answer offhand. Ask your
I will
record and then deal with
it. Let me just at least begin with the facts and show you.
But this is still in our mind because we'll have to deal with this issue, because if they are right, then we have to dismiss your review straight away.
Yes.
So you can just, when you are arguing, you can ask somebody else to verify these facts.
Yes. Now, my lords, kindly have 2 or 3 paragraphs which I had respectfully submitted, that where is the error apparent on the face as far as facts are concerned. As far as between us and the respondents, we are now the petitioners in the review petition. We were the respondents. Clearly, the agreement in question is an agreement dated 26th of March 1997. And 27th of March 1997 for the second pass. Because what had happened was, my lords, that respondent 1 to 4 sold the property to respondent 5 to 10 by way of 2 agreements for a contiguous piece of land with respect to about 127 acres. This was inter se apportioned between 5 to 7 and 6 to 10.
So R1 to 4 sold to R5 to 10.
Yes.
And when what are those dates of those agreements?
The dates are, the date they sold was 19th of March 1994.
Okay. And these 2 agreements which you said of 26th March 97 and 27th March 1997.
Yes.
Those are between whom? Obviously with you as one party. But who is your vendor?
Our vendors are 5 to 10.
Oh. So how do we describe you?
As the purchaser?
As the review petitioner.
Review petitioner and the purchaser of the property, my lords. Because really the transaction is between me and 5 to 10. Who asked for specific performance.
Right. So your agreement with respond numbers 5 to 10 is of 97.
Yes.
Our 5 to 10 acquired the property in 94, 19 March 94.
Yes.
Right.
Now, the fundamental error which happens in the matter is this, or a mistaken fact is twofold. Because ultimately, what is to be seen was the suit barred by limitation or not?
That from the
High Court ruled in our favor, dealing with it, saying that, look, clearly time was not the essence. If forfeiture of advance money within 3 months was the ground, you should have taken action then. And in any case, 90% of the consideration was paid within the time provided. Since within those 3 months, they also had to produce the documents, which they did not produce. Thus, things went on, and finally we gave a legal notice, and at the stage of legal notice, for the first time, they refused performance. So the court said that taking Article 54 of the Limitation Act, if no time is fixed, the second part is where refusal to performance of the contract is given, limitation starts running from that date. That was a reasoned order. Neither did they ever forfeit, nor did they ever say that we are returning your advance. Nothing done, no correspondence on that at all was ever done. And clearly 90% was paid on time within the 3 months. Advance was also paid. And the High Court clearly came to a conclusion, although you say all documents are available at the stage of agreement to sell, but you yourself deny they were available. They were clearly not available. And if they were available, then where was the need to put that clause in the agreement to sell on the same deal?
Agreement with them fixed 3 months time for completing?
For both things. 3 months for payment of the balance consideration and 3 months for giving the documents. And our respectful submission is that we paid 90%. And the only reason this 10% was not paid was because you were not forthcoming with your documents. And we kept approaching you, and ultimately when we sent the legal notice to you, you refused to perform the contract, and within 3 years of that, within 2 years of that, we filed a suit.
What is the date of the legal notice?
Yes. The legal notice...
Because Article 54 of the Limitation Act says 3 years from the date fixed for performance or notice of refusal.
Or notice of refusal. So the legal notice was given on 8th of February 2000.
And when was the refusal?
Refusal was on 14/4/2000. And the suit was filed on 9th of August 2002. Otherwise, I lose my... Can you explain it? When we filed. Now,
what is the fundamental error?
Yes, so that...
We are in review, we are not in appeal.
Absolutely. That is why, my lords, the fundamental error which happens is that apart from not dealing with the contentions why the High Court is wrong in what the High Court says, the order under review says, confuses with the original agreement between respondent 1 to 4 and 5 to 10
of 1994.
Of 1994, and says, since that agreement did not materialize, a last opportunity was given to you by virtue of the agreement dated 97, and thus clearly time was the essence.
But you are not a party to the 94 agreement.
It has nothing to do with me. Then it relies on...
Are you claiming rights under the 94 agreement as an assignee?
No, no.
It's a fresh agreement.
It's a fresh agreement.
Because 19 March 94 is the agreement by virtue of which R5 to 10 acquire title.
That's right.
And based on that title, you enter into the agreement of 94.
They became the absolute owners. My rights are not traced.
The agreement of 1994 is an agreement to sell?
Is an agreement to... Is it a sale or an agreement to sell? Agreement to sell.
Accompanied by a power of attorney.
Accompanied by a power of attorney.
General power of attorney.
But be that as it may, my lords, my case is that I have an agreement to sell of 1997 with 5 to 10, which they refused to perform, despite 90% of the sale consideration having been paid within the...
You are not seeking specific performance of the 94 agreement.
Not at all. Not at all. Those respondents are made signatories to this agreement only for purposes of completeness. But our agreement is only for this, the 97 agreement. It is no one's case also that I'm seeking specific performance of the 94 agreement. That is no one's case.
And are 1 to 4 and 5 to 10 are parties to your agreement also?
Yes. Which very often is done for the sake of completeness.
So it's not just that R5 to 10 are parties to the 97 agreement.
Yes.
You get R1 to 4 and 5 to 10.
As a matter of abundant caution, as happens and very often in these agreements.
Now, what is the fundamental error?
Yeah. So the two fundamental errors which occur.
Just formulate them so that then we can call upon the others.
Because then I need to show those paragraphs.
Yes.
Because that'll be important. I need to show those paragraphs.
Just formulate the two errors.
Yes, yes. The first is, the court says that you entered into the 94 agreement. Confuses, thinks I'm party to the 94 agreement. And because the 94 agreement did not materialize, the 97 agreement was an agreement by being a last opportunity. And thus time is the essence. Then it relies on clause 21 of the 97 agreement to say, and I must tell you, Lordship, what clause 21 of the 97 agreement is. Clause 27 said that respondent 1 to 4, who have already received their consideration from 5 to 10 for the 94 agreement, will have no claim to any other consideration now being paid. So it has nothing to do with time at all.
What was the sale consideration fixed in the 1994 agreement?
In the 94 agreement. What was it in 94 agreement?
It was a larger.
No. And whether that entire amount was paid by the vendor to the vendee?
Manoj, they don't have any dispute on that. They have no dispute.
So without execution of the sale deed, the entire sale consideration was
yes,
paid.
and that was a much larger piece of land. That was 129 acres.
Therefore, they are the signatories to the 1997 agreement.
Yes, but
as confirming party.
Yes, but they have inter se never had a problem with respect to their sale consideration being paid to 1 to 4. 1 to 4 have never come and said that we've not been paid our sale consideration. Yes. So, what is this?
Second, what is the second error?
Second was that you gave a legal notice where you said and narrated a story, you meaning me. I narrated a story in that legal notice to say that you were not performing and you sought other buyers, and since other buyers were not coming forward, you came back to us to complete the transaction and approached us again. Now, firstly, how does that make time the essence of the contract? Either ways, nothing turns on it. It doesn't make time the essence of the contract because that's the whole issue. Now, let me just show to your lordships 3 or 4 paragraphs of the order under review and the 3 paragraphs they are relying on. Let me just show that to your lordships.
Yes.
And most importantly, my lords, then the order under review must have also said, why was the High Court wrong in holding what it did? After all, High Court has given detailed findings, including cross-examination, wherein they admit the entire consideration has been paid during, or rather 90% of the consideration has been paid. Balance deposited in court in the suit. That order directing deposit of balance not challenged. So for a long time now, before the Supreme Court decides this matter, in the order under review, the full consideration was deposited there. 90% during 3 months, 10% later, when the suit was filed. Now please see the relevant paragraphs that I need to show to your lordships.
Of the Supreme Court order?
Of the Supreme Court order, of the order under review. My lords, has para 5 on page 3.
Yes.
The agreement dated 19/3/94 and the registered GPA in favor of respondent number 1, purchaser, that is us, Siddham Shetty Infra Projects, could not materialize. Now this is not with us. That's the starting point.
Yes.
Now kindly come to para 32. My lords, have para 32 on page 22.
Yes.
Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of forfeiture would ensue if the payment is not made within 3 months of the date of the agreements. It may be noted that as per clause 21, the parties had entered into an earlier agreement to sell dated 19/3/94, which did not materialize, and accordingly the agreement price therein was no longer applicable. My lords, I halt here for a minute and then I'll proceed. 21, I have told your lordships what it dealt with. That if 1 to 4 will have no claim to the consideration being paid, I'll read it out again, the clause. And now, it is in this context that the fresh agreements were entered into between the parties so as to provide a last opportunity for them to successfully enter into a sale purchase agreement. The aforesaid intention of the parties is also made clear through clause 23 of the agreement to sell, which reads as under 23, the parties of the second part herein undertake on any pretext they will not make any claim for enhancing the agreed sale consideration. Now, my lords, firstly, 21 doesn't talk about any last opportunity. I am not a signatory to the 94 agreement. And 23 also, by no stretch of imagination, is a clause which deals with time being the essence of the contract. Because that's all these clauses are being relied on, is to deduce whether time is the essence of the contract in the matter concerned or not. Now please see 33. The aforesaid clauses clearly frees any enhancement of agreed sale consideration which cannot be independent of a fixed time period. A contrary interpretation would render the contract commercially unreasonable and unworkable. The moratorium on enhancement of rates prescribed under 23 should be interpreted to be predicated on fixed time and be executable within a reasonable time. The same should not be utilized to render the commercial wisdom between the parties OCOs, which is inherent in drafting such clauses. Now kindly have the next page para 34. From the above analysis, it is clear that the contract was strictly conditioned on a time frame. At this stage, it may be relevant to quote section 55 of the Contract Act, which reads as under 55, effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was at the time should be the essence of the contract. Now, my lords, I halt here. Did they take any step? Was there any letter rescinding the contract sent? Was the money forfeited? Was the advance returned? Nothing. I was the one who sent the legal notice ultimately in 2000. Nothing done. So how does 55 become applicable? 55 has no application in the facts of the case. Now kindly see 35.
So much which is not performed.
Yes, and that also is only so much as is not performed. If at all it were applicable. According to us, 55 is not applicable at all. Now please have 35. In view of the aforesaid provisions, the vendors were entitled to resign the contract.
The essence of the contract in 1994 agreement?
In the 94 agreement, do we have a...
Any time period was fixed?
I'll just find out.
Check it out.
Yes, please check. Please check under the 94 agreement, is there a clause on time being the essence? Yes. My lords, may I read on?
Yes.
In view of the aforesaid provisions, the vendors were entitled to resign the contract. As there was a breach of condition, time was the essence. Coming back to the point of limitation, it is clear that Article 54 of the Limitation Act mandates that in this case at hand, the date fixed for consideration was 3 months from the date of the agreement, dated so and so. In any case, the time period for filing the suit had commenced on 26/27/697 and would have expired after 3 years in the end of June 2000. The purchaser has contended that legal notice issued by them on 31st/3/2000 would be sufficient to get past the bar of limitation, as the purchaser has paid the advance amount to a large extent. Although this argument seems to be very attractive at first blush, the same cannot be sustained in the eye of law for the reason that when a condition of a contract is breached and the consequences ensue for that breach, a party cannot claim equity to escape such consequences. In this context, we may note that Article 54 of the Limitation Act provides for 2 consequences based on the presence of fixed time period of performance. It is only in a case where the time period for performance is not fixed that the purchaser can take recourse to the notices issued and vendors reply thereto. In the case at hand, aforesaid circumstances do not come into play, as a fixed time period was clearly mandated by Clause 3, read with Clause 23 of Agreement to Sell as explained above. Now, my lords, kindly have para 38 on the next page. 38 starts there. In the light of the above, we note that the suit filed by the purchaser was clearly barred by limitation in view of the first part of Article 54 of the Act, and no amount of payment of advance could have remedied such a breach of condition. Now kindly come to para 60. On page 39. My lords, have para 60. The notice dated 8/2/2000 issued on behalf of the purchaser implicitly acknowledges the fact that time was considered as the essence, even by the purchaser themselves, and due to breach of the same, they sought novation of the agreement to sell in the following manner. However, the due efforts by my clients proved little light hope when you have strongly urged my client to take up with the balance sale consideration in view of the fact that other interested parties are not available at that moment, and you ask my clients to renew their efforts by end of January 2000, and thereafter you have promised to complete the transaction by executing the sale deed in favor of my client. Aforesaid notice at best reflects an intention by the vendor to renegotiate the terms, which was not accepted in toto by the vendor. Now, my lords, kindly have, where is time is the essence, the legal notice? Yes. Now, this is how the legal notice is dealt with. Now, kindly see the paragraphs which they rely on to say that the judgment sufficiently deals with all the issues. Kindly have first paragraph 31. I have already read out to your lordships. No, 31 I have. Please have 31, my lords. These are the paras they rely on to say that this requires no review, and even the errors which are pointed out will have no bearing because there are other paras that sufficiently deal with the reasoning. This is their argument. My lords, has para 31 on page 21. At the outset, this court has perused clause 3 of the agreement, which is in 2 parts. The first part provides for purchaser's obligations, while the second part details the obligations of the vendors to provide the requisite certificates. Although both the obligations are required to be completed within the stipulated period of 3 months, there is a substantive difference between these two sets of obligations. The obligation upon the vendors concerned was production of certain certificates, such as income tax exemption certificate and agricultural certificate. No consequence was spelled out for non-performance of such obligations. My lords, I halt here. Firstly, nothing turns on it, but there is a consequence. The contract stands cancelled, so it's factually incorrect. I'll just show the clause.
So therefore, Mr. Kaul, in this judgment, the review which you are seeking, where is the reference of 1997 agreement?
Please, Manoj.
Whether cognizance of 1997, the fresh agreement, has been taken in this judgment or not?
Only to the limited extent that it's a last opportunity given in clause 21 and 23. That's all. That's the way it deals with it. It says 94 was the agreement. You didn't perform. Then 97, last opportunity given, 97 by virtue of a last opportunity. Look at the clauses 3, 21, 23 of the 97 clause, which clearly set out the consequences in one case and not in the other case, and says 21 clause puts the last opportunity, and 23 is the commercial wisdom. That's all that it says. Now, please.
Can we see the agreement?
Yes, ma'am. Could I just complete the paras they are relying on, and then I'll straight away come to the clauses. So, where was it? Yes, my lord. The obligations upon the vendors concerned was production of so and so. No consequences were spelled out for non-performance of such applications. Factually wrong. Even for not giving of documents, I had the right to cancel. Whereas the obligation on the purchaser was to make the complete payment of the sale consideration within 3 months. The clause further mandates forfeiture of advance amount if the payment of obligation is not made within the time period stipulated therein. In this context, this court in Chandrani versus so-and-so held from an analysis of the above case law, it is clear that in the case of sale of a immovable property, there is no presumption as to time being the essence of contract. The court may infer that it is to be performed in a reasonable time if the conditions are from the express terms of the contract, from the nature of the property, and from the surrounding circumstances, for example, the object of making of the contract. Now, my lords, kindly come to paragraph 58. The other paragraphs 32, 33 I have already read out. Please have para 58, which they rely on. Last opportunity. Page 38, my lords have. From the aforesaid, it is clear that the purchaser ought to have been vigilant in the case at hand to enforce his right and could not have been lackadaisical in his approach. From the facts, it is clear that the purchaser had entered into an agreement way back on 27th of March 97, which had a clause mandating completion of the contract by payment of the remaining consideration within 3 months. The aforesaid clause was drafted as alluded to earlier for providing one last opportunity. Again, the same error. As if there's a 94 agreement and then there's a 97 agreement, which is the last opportunity. For the purchaser to make good their lapse, which had happened on the earlier occasion, which is the 94 occasion, there is no 94 earlier occasion. In this context, the time of performance of the contract, including how we will be reviewed. Just know I'm saying, gather your thought. Now, my lords, kindly have, so this substituted and that. Objections and could your lordships now kindly have the clauses?
Just the relevant clauses of the clause.
Yes, just the relevant clauses. Just the relevant clauses. Kindly have first clause 3 on page 11115 of the original SLP, my lords. Annexure P1 starts at 109.
Annexure
P1 109, and where is clause 3? And clause 3 on page 115. Lodges may take it that this agreement also refers to the earlier transaction between them and respondent 124. That is also referred to.
P1.
Yes. My lords has that?
Yes.
Clause 3. The purchaser shall pay a sum of so and so towards balance sale consideration within 3 months from this date to the parties of the second part herein. And if the purchaser does not honor to pay the balance sale consideration of 27,07,500 within a period of 3 months from the date of this date, the advance amount will be forfeited. And this agreement of sale will be cancelled if the vendors fail to furnish non-encumbrance certificate, income tax exemption certificate, agricultural certificate to the purchaser within 3 months. So the consequence of your not performing was also there, the factually wrong. Secondly, what could be forfeited was the advance amount. The High Court says, and I'll show the other clauses, that taking the whole thing into consideration, clearly time was not the essence in this matter. Please now have the next clause for your lordship's kind consideration, clause 6. On the same page. My lords has that? Clause 6.
Yes.
The parties of the first part and the parties of the second part herein undertake that they will execute a registered sale deed or deeds or any other nature of documents as desired by the purchaser in favor of the purchaser or its nominee or nominees after receiving the balance sale consideration. No date fixed again. That it has to be by this. This is the sale deed. Now please have clause 13. Clause 13, my lords, 19 and 25 give valuable rights to the purchaser. Clause 13, I'm not troubling your lordships. Clause 13, 19 and 25 and 27. Relating to raising of structures, creating of mortgage, etc. 13, 19, 25 and 27. But please have 21, on which so much emphasis has been laid on page 118, which is treated as the clause with last opportunity read with clause 23. Those are the two clauses which are read to say that this was the last opportunity. My lords have clause 21 on page 118. My lords.
Yes, got it.
The parties of the first part are not at all concerned to the sale consideration agreed by the parties of the second part. Here the parties of the first part are respondent 1 to 4. Respondent 1 to 4 and the original owners who sold it to 5 to 10. So the parties of the first part are not at all concerned to the sale consideration agreed by parties of the second part who are 5 to 10. Herein, with the purchaser, as already they have received the agreed sale consideration from the parties of the second part herein, as per agreement dated 19th March 1990.
So claim in respect to the consideration payable under your agreement to your vendors, to R5 to
Yes. And then 23. The parties of the second part herein undertake on any pretext they will not make any claim for enhancing the agreed sale consideration. Now, my lords, I put a question to myself. How do clause 21 and 23 show that time is the essence? That this was the last opportunity given, and the fundamental error starts because 94 agreement is treated as the original agreement. Then by some reasoning, which is not borne out by the records at all, a reasoning is arrived at.
One question. Para 3 of this agreement, 97 agreement, it is said that the balance amount of 27,07,500 shall be paid within a period of 3 months.
Right.
That means that the total sale consideration was fixed at rupees 38 lakhs and few thousands, right?
Yes.
What is the date of this agreement? The date of this agreement is
26th March.
26th of March 1997.
Yes.
And you said, Mr. Kaul, that you paid 90% of
Yes, I'll just...
So on the date when this agreement was executed, You said 27 is the balance. When did you when did you completed 90% of the payment towards sale?
Before 3 months.
You completed?
Yes.
So you were supposed to pay the balance 10% and get the sale deed executed.
Yes. So, my lords, please.
So why this 10% was not
because the latter half of those documents which had to be given within 3 months were not being given by them.
For that, you must have issued a notice to them.
No, no.
You didn't issue any notice.
No, it's only the legal notice. That's the legal notice is the first notice of 2000. I can't improve upon what is not there, my lord. What is there is there. We did not. It was all oral.
So
we asked them. Yes.
If we calculate 3 months from the date of the agreement, it expired on 26th of June 1997.
Yes.
Right?
Yes.
And you issued notice on 8 February 2000.
Yes.
Correct?
Yes. And my lords, wants the dates, I can give the dates also when the advance was paid, and then 90% was paid within 3 months, and 10% was deposited in the suit in court. When the suit for specific performance was filed. The reason this error has occurred, my lords, is because 94 becomes the starting point. Also for completeness, let me give you lords one fact which may not have an immediate bearing, but just as we were pursuing our rights. Now, my lords, even after entering into the agreement to sell, as per clause 27, I had the right to get the revenue records mutated. There's a clause 27. So accordingly, the revenue records, an entry was made. On their request, it was deleted. I pursued it. It was restored. And they filed an appeal against that. So initially, the deputy collector deleted the name, our name. White proceedings dated 15/2/2007. Aggrieved by the same, an appeal was preferred by us before the RDO. What is the full form of RDO?
Revenue Divisional Officer.
Revenue Divisional Officer. And the same was allowed by proceedings dated 14/9/2007. Against the same, revision was preferred by the respondents, which was also dismissed. And I'm instructed to say that there is no further proceeding thereafter.
Argued it before the High Court.
Yes, and this was argued by us before the High Court. Now, my lords, in this background, let me also show to your lordships the crucial findings of the High Court. Because ultimately, when the order under review is dealing with an impugned order, it surely has to deal with how has the High Court gone wrong.
Let's see the High Court.
कहाँ से पढ़ना है से पेज 20
He is a correct translation from the
Yes.
Telugu. It must have been in Telugu or it's in English.
It's in English, the agreement, or in Telugu?
It's in English.
It's English only.
English.
No, then there's no.
Manoj, may I now
Sometimes, translations from the local language can.
kindly now have para 19, Manoj? I'll need to read 4 or 5 relevant
Of the High Court judgment?
Court order. Page 17 of the original SLP, Manoj.
1-7. Yes.
Now, in the present case, we have to examine the suit agreements of sale, so and so, whether any date is fixed for performance of the agreement. Clause 3 of the suit agreement are extracted for ready reference as under. The purchaser shall pay 27,07,500 so and so towards balance sale consideration within 3 months from the date of from this date to the parties of the second part herein, and if the purchaser does not honor to pay the balance sale consideration of 27,750 within a period of 3 months from the date of this date, the advance amount will be forfeited, and this agreement of sale will be cancelled if the vendors fail to furnish the non-encumbrance certificate, income tax certificate, agricultural certificate to the purchaser within 3 months. It is to be seen that clause 3 of the suit agreement, 2 limbs. The first limb of clause 3 speaks about plaintiff's obligation to pay the balance sale consideration within a period of 3 months of the agreement, and consequences of failure to pay the sale consideration within the time is that the advance amount paid by the plaintiffs will be forfeited. Admittedly, no calendar date is fixed for its performance, but the payment of total sale consideration to be made within 3 months from the date of agreements. Obviously, the performance of the suit agreement can be done only after obtaining necessary certificates, permissions by the defendants 6 and 8. Thus, it is to be presumed that unless and until the defendants produce the certificates, permissions from the competent authorities, the registration of properties could not be completed. Though it is vehemently contended by the learned counsel for defendant 6 to 8 that the plaintiff had not paid the total sale consideration within the stipulated period, but the defendants have not exercised the option of forfeiting the advance amount paid as per clause 3 of the suit agreement. The second limb of the same clause speaks about the defendant's obligation to obtain and produce the required permission certificates from the concerned authorities for completing the registration process in favor of the plaintiff, and consequences of failure to produce the required permission certificates contemplates that the agreement will be cancelled. But neither the plaintiff nor the defendants have exercised the option of cancelling the suit agreements. The trial court has not understood the distinction between time fixed for payment of sale consideration and time for performance of the contract, and on wrong premise came to the conclusion that the time fixed for payment of balance sale consideration is the time for performance of the agreement, and applied the first limb of Article 54 of the Limitation Act, which is erroneous. The performance of the contract is dependent upon the factum of furnishing documents under A4 and A5 by defendant 6 and 8, and that is the reason, as rightly contended by learned senior counsel appearing for the plaintiff, that the date for specific performance of the agreement is not fixed. Then the distinction made by the learned senior counsel that there is a difference between the date of specific performance of the contract and the date of payment of the amount is also not noticed by the trial court, in coming to the conclusion that first part of Article 54 of the Limitation Act applies. As such, the basic assumption of the trial court about application of Part 1 of 54 is erroneous. Then kindly have give me a minute, my lord. Just give me a minute. Page 27 also, this has to be read.
There is a reasoned application of mind by the High Court.
On readiness, willingness, on total consideration paid, on time not being the essence of the contract, interpreting all clauses of it, and coming to the conclusion, and what is the basis of the order under it.
So this is the High Court's finding on clause 3.
Yes.
Then on readiness and willingness, which are the paragraphs, we need not read them out. But
para 35.
Readiness, right?
Para 35 to 40 on readiness and willingness.
What is the PDF page, 35 to 40 page?
Because we have a different PDF. Our PDF number is 70, but I don't know whether that...
Anyway, we check. 48.
running page 28, 35 to 40.
All right, then.
Then on payment consideration has been admitted is para. No, that's page.
Payment is what para?
Para 38 and 40 again is that the consideration has been paid.
All right, anything
38
else?
and 40. Then, and that is where they also record that their witness admits payment having been made. Then, my lords, also mutation entries are covered in para 25 to 26.
Page, para 20, page 24.
And the final finding is on page para
24, 28.
para 28.
Which starts at 23 and ends at 28.
So what the High Court does it says that we will only give you land proportionate to the 90% that you had deposited on time, and the 10% needs to be returned, and you will not be entitled to that 10% proportionate land. And they were directed to pay that amount, which I'm instructed to say even that was not paid till today.
And they denied receipt of 34 lakhs also.
Initially, they attempted to.
No, come to para 36 of the High Court.
Yes.
The witness,
Yes, they did.
the witness admitted that is.
And then ultimately that stood proved. So our case was, we pay you 90% during, why would I not pay 10%?
5,39,000 was the balance amount.
Yes.
5,39,000.
And one was a check which got dishonored. We immediately replaced it by a demand draft and the court records that the next day.
But the direction of the High Court that you should be given only 90% of the proportion part, that is accepted by you.
No, that is what we challenged in
Yes.
the SLP, and that's the second review, which was filed.
Oh, there was a cross SLB by you.
Yes. And we said if we have performed the full contract, then we should be given the land. Now the order under review says you were not ready and willing. Also, look, your DD bounced. The next day it was replaced by another DD. So that's the kind of reasoning. But the fundamental error is 94, 97, last property and clauses which are wholly inappropriate. Only on, yes.
So far as that sale of the land is concerned to third parties, which is being presented before your lordships as a ground, as a preliminary ground, what had happened was they filed a writ petition before the High Court. That writ petition, and that is dealt with in the judgment of the High Court.
Why did they file a writ petition before the High Court?
134 of 2020. They say we granted permission to sell the land. The registering authority is not registering our document. Please issue a direction to the registry that your lordship will be pleased to find at page 71, paragraph 19.
Their registration in favor of that third party.
They didn't name who the third party was.
Anyway, then.
And it is not being done, therefore issue a writ. The High Court says I have granted specific performance. Where is the question of allowing this writ? That writ.
So High Court was dismissed. High Court when was it dismissed?
It's saying by the impugned judge, common judgment which was impugned by them, but they only challenged that portion of the judgment which was in first appeal, not in the writ petition. Therefore, all of the purchasers cannot be said to be bona fide, is my respectful submission. That's at page 71.
So no challenge to that, the writ petition
Yes,
order.
because their SLP says, I read the prayer. The prayer is at page number 99.
Were the purchasers parties to the petition in the High Court?
No, they didn't disclose, Malone.
Oh, I see. They didn't say the names of the purchasers.
There is grant special leave to appeal against the impugned final judgment and order dated 23/4/2021 passed by the High Court for the state of Telangana at Hyderabad in appeal suit number 998 of 2010. No challenge to that.
It's a suit for specific performance.
Yes.
We got your point. All right, let's hear the other side. Yes, Mr. Dwivedi.
Look, to begin with the last point which Mylan has taken up, the sale deed has been executed after the judgment of this honorable court. So the fact that a petition was filed in the High Court and was dismissed has no relevance not to the objection which I have taken. Because after the judgment of this honorable court, my lord, I was entitled to proceed to register the sale deed.
Yes.
So therefore, this reference to the High Court dismissing blood is bereft of any substance. The second thing, Lord, which your lordships asked my learned friend, Lord, to confirm the date of serving notice, which they have not. The notice, Lord, the process fee was deposited by them on 5/10/1924 or 2024. After my Lord Justice MISRA had issued notice in September. And it was served on by email on 9/10/24. Which is 2 years after the registration of the sale deed. It was delayed, my lord. I have already submitted to your lordship, my lord, and I submit it squarely covered by lordship's judgment, my lord. We can't, a winning party is not required to wait for 2 years, my lord, for notice to be served and then, my lord, to proceed. If the Limitation Act prescribes 30 days, is in possession and utilizing the property ever since the sale deed was registered. And in the absence of the third party, my lord, if the order is recalled, then his vested right is impacted. My learned friends say, my lord, doctrine of lease pendants will apply. The submission is, my lord, the lease pendants doesn't apply because some petition has been filed in the registry without getting it numbered. That is a point when even the registry has not taken cognizance of the petition. Your petition is lying defective. You have chosen to keep it defective. Was registered on 13th of December 22. And the sale is before that. The winning party was entitled to execute the sale deed. The purchaser was entitled to pay off the money and buy the land. And there was no injunction of any court. No legal doctrine which prevented the parties from so acting.
Yes.
So therefore, this is the ground on which alone, your lordships, in view of Vedanta's judgment and otherwise also, there are serious latches, in this case, in the way in which the review petition was filed, processed, and got adjourned by moving a letter. So this is a very serious matter, and therefore petition should be dismissed on that ground alone. Now, so far as the merits are concerned, I am confining myself to the review application. And if I may just state for my own convenience, that in review, this court will not sit in appeal, nor reappraising the whole evidence, because it's possible that your lordship may take a view that if we were deciding the matter originally, we may have taken a different view of the matter.
So we have to only see if there's an error apparent on the
There's
face
an
of record.
error apparent on the face of record of such an egregious nature that in review petition, the highest court should intervene, my lords. And to point out some error here or there, equally, your lordships have said that there may be some errors, some discrepancies about noting the facts or bringing out their interconnection. That alone will not justify, my lords. It's an overall sense, which, because it's a specific performance matter, my lords, which is in a discretionary domain. Now, in this case, is not one where the agreement of 97 has not been noticed at all. Clause 3, 23 have been noticed. 3, 21, 23 have been noticed. Some of them extracted. And paragraph 58, which my learned friend read out, clearly shows that the court is cognizant of the 97 agreement. Now, what are the three features, my lord? Yes, I will confess, my lord, that this reference to 94 as surviving or having some bearing, etc., that part, my lord, is erroneous. But that, in my humble submission, my lord, looking at the whole judgment, the judgment proceeds on three things. One is it's the court's understanding of clause 3. And read along with that, the court takes notice of clause 23.
That's one.
Yes, if your lordship adverts, since your
lordship, I remember that.
Lordship saw the agreement.
Can you formulate the second point? First was judgment proceeds on three things. One, court's understanding of clause 3 plus clause 23.
Yes.
Then the second?
Clause 3, 21 and 23.
21 and 20. Right.
And please bear in mind, my lords, that the theory that time, in case of immovable property, time is not of an essence. One is not an absolute principle.
It can be overridden
and
if
has
parties
much
make it, if parties make time.
Depends on the contracts,
Yes.
the understanding of the specific terms. Not only that, the times have changed from those not initial in the 19th century when the property escalation of prices moved very slowly. But that was a time, my lord, when the High Court judge's salary was 3,500 rupees. And in Supreme Court also it was 4,000. So slow escalation period. We have moved on to a fast escalation time period, or rather era. And even in this era, there are certain zones, metropolitan zones, where it's very, very swift. clause 3 and 23 are a consequence of recognition of that fast moving, fast escalating situation. Why does it say, my lord, 3 months? And so first is the short period prescribed, 3 months. Second, and this impugned judgment which is sought to be reviewed notes repeatedly. The second is that it is clubbed with forfeiture, will be forfeited.
So your argument, Mr. Dwivedi, is, if we have understood it correctly, so far as looking into 1994 agreement is concerned, by this court, it could be said to be an error.
Yes.
But ignore 94, look into 97, look into paras 321 and 23, but for the second limb, perhaps they would have no case.
Yes.
High Court says, yes, within 3 months, you were supposed to make the payment towards the balance sale consideration. But the second limb says you have to produce these documents to enable for to get the execution of the sale.
Yes, appreciate. Kindly, if you, I'm sorry if I've interrupted.
Correct.
The clause 3 has two distinct parts. The production of document is just not linked. There is nothing in clause 3 to show that my production of documents, obtaining of documents, etc. is dependent upon, and you can withhold any portion of the amount on account of
your contentious clause 3. There are two independent obligations.
Yes, that's why I was requesting.
We got your point that you have to pay us completely within 3 months.
That's right.
My obligation, if I don't perform, the agreement will be cancelled. That's your argument.
You can cancel it. That's your discretion to cancel.
So your argument is the day 3 months time period expired, the agreement stood forfeited.
Forfeited.
And if that be so, from that date, that is June 1997, within 3 years, the suit should have been filed.
And that's what the view
by virtue of the first part of Article 50.
And that's the view taken by this.
That is your argument.
That's my humble submission. And I'm adding, my lords.
And actually, therefore, you are sustaining the judgment aliende. You are
aliende of that 94. I'm saying exclude it. Excise it from the judgment. And let's see whether it is sustainable on its own strength based on it. Now let's look at it. 23 is the most crucial, my lords. 23. That my learned friend did not read out to your lordships. Start on paragraph 35. Just really complicated.
You read it out. We read it.
23 says that it deprives me of any staking of any claim for revising the price. So therefore 3 and 23 go together, sail together, intricately interlinked. If I just read from the 3 lines only, the parties of the second part herein undertake. So I have undertaken on any pretext, they will not make any claim for enhancing the agreed sale consideration. So you can't go on speculating. It's not a question of 5 lakhs or 7 lakhs or 10 lakhs.
But if the payment within 3 months was mandatory, as you now assert, why was the reason to put clause 23? Clause 23, because if payment is to be made within, say, 3 months.
So, Lord, that shows that it is expected you will pay in 3 months entire money, because otherwise, I can raise if 3 months go, then I can ask you to raise the price. That's why, Lord, in their letter, the Supreme Court notes that there is some indication that you wanted renegotiation.
You got the point.
So, therefore, I submit, Lord, that, and apart from this, if the Lordship comes to the judgment, the last paragraph 76 to 79, connected with this, that assuming it's not of essence, does it mean that you can just sleep over it for 2 years? You issue a notice after 2 years. I can understand instead of 3 months, you are coming after 4 months or 5 months or 6 months.
So really one question, why did you not forfeit? You never forfeited, right?
Yeah, according to us, Lord, the forfeiture is automatic. That's why 23 freezes my rights. Otherwise, that 23 has no meaning. It means that you will wake up and after 5 years and then you will come with 5 lakhs and ask me, kindly see the injustice and
Actually, this clause 3 in the agreement is not happily worded.
Not happily.
It has created a lot of complications.
Yes. So, kindly see the iniquity inbuilt. If our view is not accepted, then that means you can wait for 5 years. Still, the price will be 40 lakhs, and then you find some buyer today and sell it for 20 crores. That's the idea of freezing. It's a fast escalation zone, so 3 months. Until then, I have no right to review.
Okay,
now we are in 2024, Lord, and 97, and the prices have gone up beyond imagination. And Para 31 clearly interprets clause 3. The two parts are distinct. So para 35 and 58, they discuss. Then 79, the last submission is that in para 79, the court records that it will be wholly, we are of the firm opinion that the contract was breached due to the conduct of the plaintiff purchaser who were not willing to perform their contract after entering into a time-sensitive agreement. In any case, it is an admitted fact.
Where do we get that, Mr. Dwivedi?
Para 79.
At internal page?
Page 50.
Page 50?
Yes. Of the review petition, Millers.
No, okay. 79. 79 begins with
we are of the
admittedly?
No, we are of the firm opinion.
Oh, sorry. Yes. I was looking at the High Court judgment. Sorry. We are of the firm opinion.
Yes. That the contract was breached due to the conduct of the plaintiff purchaser who were not willing to perform the contract after entering into a time-sensitive agreement. In any case, it is an admitted fact the plaintiff had paid only part consideration. Though there is a forfeiture clause in the agreement, this court, with a view of rendering complete justice between the parties, deems it appropriate to direct. So the court is now exercising a discretion. And in review, specific performance is a discretionary domain. And there is no review of the discretion. Supposing after noting all the facts, the court says that we don't feel that in view of their conduct. And there is no perversity involved. They balance the entirety of thing and they take a particular view. I submit, I recall just one judgment, of Jammu Kashmir, It's a service matter, and law settled was that the eligibility should be seen on the date of advertisement.
Yes.
Now, in that case, the engineers, they had appeared in the examination, but the result came later. They were accommodated and appointed. They worked for 7-8 years. And the matter came to this court before 3 honorable judges. Then 2 learned judges took the view that they should continue and their qualification subsequently is fine, no illegality. Justice Sahai took the view that no, this is illegal, but exercising 142, etc., they've been working for a very long time and therefore they should not be disturbed. So ultimately, all 3 judges, there was a review petition and Justice Jeevan Reddy was presiding. So their lordships came in and they said, Mr. Jain, R.K. Jain, the late Mr. R.K. Jain, he said, please sit down. We are with you. Last date will be the date of advertisement. Let's hear the other side. So when I was called upon, I said, yes, this is wrong. it should be the last date of advertisement. But I said that this is a discretion domain where all three judges have united and said they should not be disturbed. So that part should not be reviewed. There can't- That's a judgment which is reported.
That's okay.
Yes.
Thank you, Mr. Jaydev. Mr. Rodgi, anything you want to add?
Yes, my lord. Yes, only five minutes, my lord. I have heard everything. I will make only one line submissions, my lord. One, my lord, the review petitioners have forfeited their right to be heard by this court in view of their machinations in filing, processing, and having the matter listed. At this stage now, my lord, more than 2 years after the judgment. That's number one. Number two, your lordship's view is taken on these issues. Mayawati's case, my lord, I am not citing. Number two, my lord, the most important thing in a review is not substitution of the view. Whether your lordships take the view on clause 3/23 of the 97 agreement, contrary to the view taken by the judgment under review, can never be a ground for review. Your lordship may note, my lord, it is well settled. This is, my lord, that Mayawati's case, 2013, volume 8 SCC, page 320, and the principles are summarized, my lord, at page 320, at 333, at 333, paras 20, para 20. So no substitution of the view because the lordships are not sitting in appeal. The second important feature of a review is, my lord, not a mistake here and there, but something which affects the soundness of the judgment. That is the words put by your lordships. And that also your lordship will get, my lord, in the same judgment which I have cited and in the same para of the principles. That soundness of the view. Therefore, consideration, my lord, of the 97 agreement in totality is, my lord, soundness of the view, because in our submission, clause 3 gets its teeth and bite only from 23. It is like a sequitur. 3 months and you, Mr. Seller, will not increase the price. That is the teeth and the bite given to 3. And next, my lord, your lordships asked a question about the documents which are in the other part of clause 3 which I heard. Para 67 of the judgment under review, if your lordship will see, clearly records a finding that the seller's evidence shows that the buyer had seen all the documents in advance. And as such, there was no reason, my lord, to doubt the issue of documents, and that was a non-issue. That is in para 67. So, my lord, by removing now 94, it is clear, is only a historical background of recital as to how transfer of title took place. It has no relevance, my lord, between me and Mr. Call. It is a historical recital, A sold to B, B sold to C, C sold to C. There the Supreme Court made a mistake, as if, my lord, that contract had anything to do with the contract between Mr. Call's client and me. But that does not affect the soundness, my lord, of the discussion and interpretation of the 1997 document. And, my lord, paras 31, 32, 33, etc. Sorry.
What mistaken refer? Then what is the next point?
Yes. So, my lord, I had indicated to your lordships last that without 94, which was a historical recital, the judgment is sound on the 97 agreement. In coming to the conclusion, my lord, that time was of essence and these people did not pay. Therefore, my lord, by conduct and by efflux of time after 3 months, the bargain came to an end. This is a matter of construction of the document and the evidence on record. Then I mentioned to your lordship para 67, where the judgment records that all the documents were seen and examined by the plaintiff and was satisfied, and that part of clause 3 is a non-issue. Now, my lord, something very important. If, my lord, time was of essence and 3 months operated on its own, then the cause of action, my lord, was in 97. Therefore, limitation would end in 2000. Now, it is important to note that they, my lord, issued a legal notice on 8/2/2000.
That date we got right at the outset.
Yes. So that is, my lord, just 1 month short. If you calculate limitation, my lord, I mean, if you calculate from 97, the limitation is over. Sorry, not 1 month short. From 97, it is 2000. So they issued a legal notice, my lord, only in a manner to somehow create an extension of limitation. And you cannot extend limitation of your own volition. That is recorded by the judgment under review at paras.
Your fundamental point is that limitations started running in June 97. Therefore,
Yes, it started running, my lord, because the time fixed for performance under Article 54 is 3 months, where the price will remain frozen. And they did not lift a little finger after 97, 98, 99, 2000, when they issued a self-serving notice which cannot extend limitation. And then, my lord, they filed a suit, my lord, in the year 2002, August 2002. Now, this part, my lord, is also, my lord, recorded by the judgment under appeal in para 35. I am not reading. This is also, my lord, considered. Now, something very important. My lord, the final deposit in court of the balance was only on 11th of July 2005, pending suit. So, what you had to pay in 97, my lord, in the middle of 97, you make it up in July 2005. 11th July 2005. It is mentioned, my lord, in the petitioner's list of dates at page 6. It is from there that I have taken the date. Now, my lord, apply a reasonable view which the Supreme Court took on limitation and on conduct. Now, it is, my lord, well known that you have to be ready and willing from the date of the contract till the date of decree. And, my lord, even in execution, when you have to pay, you have to remain, my lord, ready and willing at all times. Now, look at their conduct. And this is examined by the Supreme Court. My lord, your lordship could take a different view. But having taken that view on a totality of facts is certainly, my lord, not a case for review. Now, my lord, your lordship may note a very recent view of this court on the issue of limitation in a specific performance case in regard to this clause of the Limitation Act, Article of the Limitation Act. 2024 SCC Online SC 1915, my lord, by the bench of Justice Vikram Nath and Justice Varale. My lord, it's a short judgment. My lord, if your lordship will have a look, yes, kindly have a look at this, my lord. Kindly turn straight, my lord, to the second page at the foot para 9. after reproducing clause 50, Article 54. First is the date fixed for performance. That's the primary thing. And if there is no date, then you go into effect. So, my lord, 54 is split legally, my lord, in two parts. And it has been held that the first part, my lord, is decipherable. The second part, my lord, will depend on evidence. In regard to the first part, my lord, in our case, it is 3 months. Now, my lord, see what was in this case. Coming to the facts. Sorry. My lord said, sorry.
We've seen the agreement.
Yeah. So, my lord, just para 9.
Para 9 we have seen.
Yeah, your lordship, see, that was a case of 1 month, my lord. Mine is a case of 3 months. Price to remain frozen. Limitation sought to be extended by a self-serving notice. And today, my lord, we are 2.5 years down where the property has been sold. Is it a case, my lord, where the exercise of review should happen so as to, it's very well to say, oh, lease pendants and all that. But, my lord, can you now turn back everything when you have really lost? You have lost the plot, my lord, it's all over. And therefore, my lord, with respect, my lord, the review should be dismissed.
5 minutes by the floor for the rejoinder.
Mr.
Paul.
Can I pass on this small list, my lord? The view on limitation has always been so, my lord. So we have extracted all the judgments in this.
Mr. Paul, what is the impact of clause 23 on clause 3? Their argument is that clause 23 necessarily makes time of the essence of the contract.
Let me just answer.
All right.
I'll start with Mr. Rodgi's submission and then come to Mr. Devedi's submissions. Manoj, with great respect, my learned friend was completely incorrect factually. He read out para 67 of the order under review to your lordships. That para 67 talks about documents being available with the respondents. That has been negative by the trial court and the high court, where their own lawyer has admitted it was an incorrect statement when confronted and the documents were not available. Please note those paragraphs.
Yes.
Para 39 and 40 on page 31 of the high court order. Read with para 70 and 72
of the trial court?
No, it's High Court order para 39 and 40.
That you got.
Yes.
70 and
then
72.
Para 70 and 72 of the trial court order at page 215 and 216 of the SLP, which categorically records, I'm just reading out 2 lines and then your lordships can see it later. On the other hand, the learned senior counsel for the defense fairly admitted that the pleadings so made are incorrect because the defendants have not obtained such certificates. My learned friend, with great respect, is arguing contrary to record.
67 is also common.
And para 67 is another error apparent on the face of the record. That's again an error apparent on the face of the record because you're going contrary to the categorical findings of the High Court and the trial court without showing how they are incorrect.
There's no such ground taken in review petition.
That's why I didn't interrupt my learned friend. My learned friend will show the same courtesy to me. My lords, may I with respect now say, the words used in clause 3 are and, with an and. It has a material bearing that the two are not independent limbs, go hand in hand. And as my lords put a pertinent question, which sale deed will be executed if you don't get these certificates? You're practically negating the transaction and reading clause 23 out of context. But also it's very important, let me tell your lordships, this whole argument of Now, my lords, please keep in mind Manoj, may I?
Was 23, which date did he issue notice?
Now, my lords, as far as clause 3 is concerned, it talks about forfeiture of the advance. The words are, what will be forfeited is the advance, not the entire consideration paid. My learned friend comes up with an oversimplistic answer to say, I took it as an automatic forfeiture. So you forgot about the other amount also paid to you. The words used in clause 3 are, if you are right, is forfeiture of the advance, not of the entire 90% sale consideration paid. And my learned friend's only answer is, I take it as automatic forfeiture, ignoring all provisions of the Contract Act that ordinarily when you revoke a voidable contract, it is by virtue of a notice, a communication. That's what section 66 of the Indian Contract Act says. In any voidable contract, there will be some proper communication. Not only do you pocket the advance amount, you pocket 90% of the sale consideration as well, and you don't feel any need to write to me resigning the contract. The words are categorical.
All right.
Your advance was 11 lakhs.
Yes.
5 lakhs and 6.
So you forget about the 90% and no communication, no letter. That's also an automatic feature as per clause 3, as per you. You're reading into a contract which is not there. Now, my lord, is very important because this is with great respect and an argument of prejudice made that we delayed it. And I want to tell your lordships why. We never delayed this. Our review
It's filed within 30 days.
Our review is filed within 30 days. Within 15 days, the defects are removed. You received a phone call. If your lordships were to go to the website, there are nothing to suggest that we delayed removal of defects. There we removed the defects within 15 days. And now I'll tell you, lordships, what happened. In September 2022,
26 September, exactly the date.
even before they sold the property, that High Court order that Mr. Raval showed to your lordships came in, where they did not make us a party.
No,
Where
that
they-
is different. That order is along
No,
with,
and
they filed another
writ petition, another order came.
anticipatory writ petition.
So in
That means-
January 23, we wanted to place these documents on record because we are doing things behind our back. We wanted, for completeness of narration, wanted to place all these High Court documents on record. Now, between January to when your lordships in August 23, my lord the Chief Justice issued notice for an open court hearing in the matter with which Justice Kohli disagreed. And then ultimately the whole issue took a year and it came up in January 2020. It came up in 2024 September when Justice Mishra's order came. Where is the fault on my part? Everyone has gotten up here and made the most irresponsible statement that we waited for a judge to retire. We removed the defects on time. We did what we could. In January, we wanted to bring documents on record. We did. After that, your lordship issued notice in August 23. After that, it took a year for this whole process of disagreement between Justice Kohli and your lordship's order for an open court hearing. And that was finally settled by the order of Justice MISRA saying it should be an open court hearing, which was in September 2024. And in between, Justice Narasimha recused himself from the matter. Where is the delay on our part? I don't here control the registry that I'll get a matter listed when I want. Registry functions according to its own principles and the requisite independence that it has. The matter came up when it ought to have come up. How do I control all this? And you're attributing delays to me in this matter? Then, my lords, the next point for your lordship's kind consideration, and I'll cite two judgments. It has been said that not every error is what your lordships looks at. Your lordships have time and again said two things, and I'll just cite two judgments for your lordship's kind consideration. The first is where the court commits an error on fact and the same materially affects the judgment, review is maintainable. That is Sri Nevasaiya versus Sri Balaji, 1998, Volume 8, SCC 312, Para 2, Para 7 and Para 9. 8 and 9, Para 2, Para 7, Para 8 and Para 9. Then, my lords, your lordships have said in two other judgments that any error apparent on the face of the record or a misconception of fact is a ground enough for review. And that judgment is, my lords, Board of Cricket Control versus Netaji Cricket Club, 2005, Volume 4, SCC 741, Para 90, and S. Murali Sundaram versus Jyotibai, 2023, SCC Online, SC 185, Para 15. And lastly, my lords, Karnail Singh versus State of Haryana, 2024 SCC Online, SC 961, Para 20 and 20.1, summarizing the principles.
Just repeat it again.
Which one? The last one, my lord? Karnail Singh versus State of Haryana, 2024 SCC Online, SC 961, Para 20 and Para 20.1. My lords, our respectful submission is that there are 4 material errors and misconceptions of fact which are germane, materially affect the outcome and go to the root of the matter. And those are treating the 94 agreement as the agreement between us and the respondents.
Just one second. Yes.
Treating the 94 agreement as an agreement between us and the respondents. Then completely, which I'm not a party to, then completely misinterpreting clause 21 to say that was the last opportunity and thus time was the essence. 21 has nothing to do with time. It only said that respondent 1 to 4 would have no right to the consideration. The other error was treating 97 as a last opportunity, relying on 21 as if 94 was some agreement I did not fulfill due to my faults, and thus time is the essence.
That's the second.
Yes, that's the second point. Then thirdly, in Para 67, a material error by saying that they were ready and willing and the documents were available, which is in the teeth of the High Court findings, which I told you, which I pointed out to your lordships. Fourth error is reading clause 3 and 23 in a manner which is not borne out from the record. 3 specifically says you can only forfeit the advance amount. The word "and" is used there. The sale deed clause 6 does not have a time period for execution of the sale deed, and you pick up clause 23, which says that the sale consideration is frozen and say time is the essence, ignoring the words of 3. And 3 said, as your lordships rightly put it to them,
clause 23 and clause 3 and 23, contrary to the record, you said clause 3 provides for forfeiture
of only the advance amount.
Advance.
The words used are "and." The 2 limbs go hand in hand. And you have no notice. My learned friend's only answer is it was automatic feature. What about the advance 90% consideration? The documents I have pointed out, they did not have. I have shown the paras, they did not have those documents at all. Then the legal notice.
Should it not be construed to be understood? Whatever you pay till the last date of expiry of 3 months will stand forfeited.
With great respect, my lord.
Because
yes,
on the date when the agreement was executed, you had paid 11.
Yes.
You were supposed to pay 27.
Yes.
And by the time the 3 months period came to an end, you deposited more, something more. Only 10% was left.
Yes.
So should this not be construed as whatever is paid till the expiry of the period of 3 months will stand?
11 was separate. 11 lakhs was advance amount.
Understood.
Surely, I'm just attempting to assist your lordship.
What is the idea in saying that the advance will be forfeited?
Yes, the advance is the advance amount given, not the sale consideration after that. How can advance be read to mean the sale consideration?
Be a part of the sale consideration.
Yes. Unless the clause is defined. Clause 2. Please have, this is the agreement. Manoj, please have page 114. Please have page 114, clause 2. Advance in earnest.
5 lakhs plus 6 lakhs.
Advance in earnest money are defined there. Manoj, how can a party say that I will read advance in earnest money, which is defined in the contract, as to meet the 90% of the sale consideration as well? Just one more thing, my lords. Please have para 79 for a minute, my lords. That is the last issue I want to deal with, list pendants, just for a minute, my lords. Para 79.
Of the Supreme Court judge.
Of the order under review. Kindly have about 5 lines down, though there is a forfeiture clause. My lords, has that?
Yes.
Though there is a forfeiture clause in the agreement, this court, with a view of rendering complete justice between the parties, deems it appropriate to direct that the vendor's appellants to repay the said amount with interest or so and so from the date of such payment was made by the purchaser to the vendors till the entire amount is paid back. And then see the last para, the appeal is allowed on the above terms. Even if I take their case to be correct, which I am not admitting, this amount is not paid. And the order under review,
it has been paid, deposited.
According to us, not.
It has been deposited in court.
No, you can deposit in court, not to us. Now, according to us, in any case, that's a separate issue. But the fact remains in the matter is, these are my instructions, the fact remains is, list pendants under section 52 starts when institution of the proceeding takes place. The dates are clear. I filed my review within less than a month of the judgment being passed. It's not that I was waiting. If I was waiting for every judge to retire, I would not have filed my review within less than a month. So don't make these allegations which have no basis at all. And then after that, my lords, you after that sell the property. And then I've explained that you filed writ petitions where I'm not made a party. I tried to bring those documents on record. I removed my defects within 15 days. And since then till August 2023, the first time notice is given for open hearing, and then August 23 to September 24. The issue of open court hearing is decided. It comes up after that for an open court hearing, and your lordships then lists it immediately thereafter in October and in November now for an open court hearing. So where is the delay on my part? And as far as list pendants, 52 squarely applies. The party who buys from you buys with whatever encumbrances that come with the rule of list pendants. If you succeed, he succeeds. If you don't succeed, he doesn't get a superior right. And that is why, my lords, I showed clauses of the contract.
There's one very
heard now both sides.
One very important portion on their conduct. Their conduct is reflecting in what is told to your lordships as far as back on 16/5/2023. They say that we sold this property on 14/10/2022 after the judgment of this Honorable Court, of which we are seeking review. On 16th May, my lord, they say the respondents in the caption review petition are trying to get the property surveyed. However, the review petitioner is objecting with the said government surveyor, citing pendency of the caption review petition to stall survey as such. Respondent, who is almost 80 years old, is not able to enjoy the orders passed by this court even after 8 months from the date of the order. That transaction is a sham because they go to the High Court on 26th of September,
Is this
2022.
Anyway, that's where we'll consider.
But may I say just two sentences?
No, it's okay. Really. Yeah.
Just two sentences.
Yes.
The word "and" in entry tax for 3 and 4, your lordship said when it is with power, then they are not conjunctive. Then because there are two powers, 3 months I forfeit,
for 2 minutes.
3 months you cancel. They're two different.
We'll come back in 5 minutes. We're just rising for a little comfort break. We'll be back. But this argument's concluded, Judge.
And our submission is there is no cause for recall.
Extremely grateful, my lords.
Please, Lordship.
With your Lordship permission, Your Lordship, I have moved an application for intervention in this matter, Your Lordship. I am the original complainant, father of the girl who has committed suicide. Your Lordship, I was also allowed before the Honorable High Court.
That's all.
Please, Your Lordship, I thought I should mention
You've already
this.
granted bail, right?
Yes, Lordship.
Interim bail has been
Last
granted. This was in the FIR under 306.
306.
So we've already granted bail by our order dated 30th September 2024. So we make that absolute.
Yes, but Your Lordship, that was in my absence. That's why I thought
So far as the original FIR under 376 is concerned, he has already been granted bail in that. Now this was a FIR under 306 and he was in jail since 16th May 2023.
It's true, but
until we granted him bail on 30th September
Your Lordship, may I
2024.
just submit one?
Section 306, he was inside for 1 year and 3 months. We granted him bail.
Your Lordship, may I just submit one thing, Your Lordship? Your Lordship, this is a case and similar incidents are coming every day. Even in today's newspaper is also there is a news.
No,
Your Lordship, when they viral the personal photographs and videos of the girl, and many girls are there who have committed suicide. Your Lordship, even in today's newspaper there is a, and Your Lordship, here also Your Lordship.
So intervention allowed. उनका भी नाम लिखो. By an order dated 30 September 2024, this court, while issuing notice, granted interim bail to the petitioner in the following terms. वो order copy कर लीजिए. To stop, the petitioner has already been granted bail in connection with CC number 250 of 2023, registered under sections 376, 323 and 506 of the Penal Code and section 67 of the Information Technology Act. However, he was denied bail in connection with FIR number 340 of 2023 for an offence allegedly punishable under section 306 of the Penal Code at PS Shikohabad, Firozabad. The petitioner was arrested on 16 May 2023 and was in custody until he was released in pursuance of the order dated 30 September 2024 passed by this court. Bearing in mind the above facts and circumstances, we have the view that the continued custody of the petitioner would not be necessary. The charge sheet has already been submitted.
Yes, Lordship, charge is already filed. Charges have been filed, but witness has not been examined.
Charges have been
filed.
Next.
Your Lordship, I will just say one
order
thing.
dated 30 September 2024 to stop. The petitioner shall continue to remain on bail subject to such terms and conditions as have been imposed by the trial court.
Your Lordship, one thing. Your Lordship, still he is having a group of WhatsApp group and he's putting photographs in that. And it's a different, I've got record of all that.
Can apply for cancellation.
Your Lordship, this may come, he will not.
The bail would be liable to be cancelled then.
Your Lordship, it may come in the order. Your Lordship, at least now he will not pass any WhatsApp group, anything in the WhatsApp group. Because Your Lordship may just see. It will be further humiliation to the family, Your Lordship.
Apply for cancellation if he has done anything wrong thereafter.
Your Lordship may say so. Your Lordship,
that's the right open.
but Your Lordship, once this court passes the order, then Your Lordship, no court interferes. If it may come, at least then court may consider, Your Lordship, if he does anything, then because this may come.
Item 3.
Much of.
Lord, annexure
A13,
my lord. The Lordship may see the office report, my lord. One of the aspects of PMLA made applicable without jurisdiction. Page, my lord, 414. My lord, this is Agra Nagar Nigam, my lord, the municipal authority with regard to the, my lord, treatment plants. Kindly see, my lord, page 414, annexure A13. A similar direction by the learned NGT, my lord, the Bombay Municipal Corporation has been stayed by your lordship, my lord, which is order of this honorable court dated 10th of May 24. This is the first aspect.
Yes.
Second aspect is, my lord, that the parameters to be laid down by Ministry of Environment and parameter laid down by a committee of the NGT. The second issue is pending before this honorable court, which is, my lord, page E, the details are given. Well, there are some parameters with regard to the discharge, which are notified by the Ministry of Environment in 2017. In a matter, my lord, the learned NGT on the report of some committee, my lord, raised the parameters, which issue is now pending, my lord, in Nitin Deshpande, which is mentioned at page E, my lord. the matter is taking your lordship's attention.
PMLA के तहत कोई PMLA at all.
Lord, if your lordship may kindly see paid one.
Because 198.
I quote your lordship, Lord, 187. It is not put in the operative portion, but if your lordship may kindly come to page 187 of the impugned judgment.
Come to para 383, Mr.
Yes,
Singh.
my lord, I'll just, I know. Yes, my lord, your lord.
In the final, the conclusion part.
Yes, my lord.
Except the amount to be deposited towards compensation.
There is no other.
There is no other direction and prosecution.
My lord, kindly just see.
The Water Act.
At the most, we can clarify that there is no direction by the court under PMLA.
My lord, that's the kindly see, my lord. I'll just want to point out page 187. 187. My lord, that flows from there, my lord. 187, para 357, criminal liability under PMLA. Your lordship got it, my lord? 187, your lordship may kindly see, my lord, the discussion which takes place. 192 is the amendment, which, my lord, is pressed into service. 192. And, my lord, that direction. Well, para 384,
So we can say that, these observations on PMLA were outside their jurisdiction, and we can, therefore, that will not affect you.
My lord, that's first point. Secondly, my lord, Nitin Deshpande, my lord, if your lordship may kindly come to page E, where they said you have not complied with the requirement laid down by the NGT on the basis of some committee. That appeal is pending, my lord, because the compliance is with the standard laid down by the Ministry of Environment. There is a 2017 notification of Ministry of Environment, which is putting particular standard. The standard by some committee appointed by the NGT were sought to be increased. Matter is brought here, it is pending, which is mentioned at page R. Thirdly, my lord, in 2017, your lordships had decided that the STPs, etc., of various municipal corporations are to be laid. Now, my lord, in 2019, my lord, the application was filed because one more STP, which was to be installed by Agra, some trees were to be cut. So that application was filed before your lordships in 2019. My lord, it could be taken up because of Corona and various other reasons in 2022. And the application was allowed. Now, my lord, 2022 to 25, my lord, the April 2025, it is going to get ready. But the time is being taken, my lord, from 2017 and the penalties ought to be imposed. The moment, my lord, permission was granted by your lordship.
But that means, Mr. Singh, the sewage has been discharged for a couple of years without being treated in the STP. This is a big problem across the country. And rightly, the steps have been taken by the NGT.
No, my lord,
what did you do with the STPs? Did you even try to repair the STPs? So that it performs at the optimum levels. No STP. There's a straight discharge in the river.
Nobody can dispute that. It has to be covered.
So therefore, what we'll do is we'll affirm the order insofar as the deposit of environmental compensation is concerned. PMLA will clarify that these observations are unnecessary.
The municipalities do not have any resources. They are going to utilize, the project is on, it is to be now operational in May 2000.
Ultimately, the government will fund it, and this has to be deposited with the UPPCB. You have been directed to deposit it.
The STP was to be constructed in 3 years. My lord, after the lordship granted permission, the tender was taken out. 3 years are going to get completed in April 2025. Next year, my lord. And the penalty is imposed that you have delayed it. The application, my lord, for COVID and variety of reasons were pending for 3 years here. And
you moved an application in what matter?
My lord, in this very matter, my lord, one more STP.
Justice Chair's bench, I remember I was a party to that bench. We had said STPs to be installed.
When your lordship said, my lord, 9 STPs were already existing. One more was to be done. My lord, in the tree plantation, my lord, there were some trees to be cut. That proposal, my lord, was approved by the Central Empowered Committee, and the application, my lord, was filed in 2019. I placed the order on record. That application for variety of reasons, my lord, the bench being not available, then COVID, and then it's taken up in May 2022, and my lord, since the recommendation is made, it is allowed. And then it invited a tender. Tender is given in 3-year period and on May 25. It is, my lord, substantially constructed. It will be set up in May 25. This penalty amount will be utilized, my lord, for augmenting the measures to be taken. It's directly there, my lord. I can show that order of May 22 passed by your lordships.
Minimum 375.
Old my lord, your lordships have granted extension in those cases, my lord, where the
To move the NGT. That's all no.
so my lord, that reason is not, that's beyond us. Your
But
lordship is right.
Mr. Mahinder Singh, these corporations have done nothing. And look at the way the rivers are getting polluted.
My lord, that generally your lordship is right, but in this case, my lord, your lordship were dealing with this matter on day-to-day basis in the sense, my lord, your lordship remanded these matters to be heard by the learned NGT, and NGT, my lord, had to consider whether there is any delay or not. Here, my lord, the permission granted is in May 19. The application filed in April 19, permission granted in May 22 with the positive recommendation, and immediately tender is floated. It is going
When did you move this court for permission to cut trees?
2019. It's a part of the record. The idea of 2019 allowed in 2022, May 2020.
Forget about the new STPs which are going to come up. Read para 338, Mr. Singh. Very disturbing.
Malad, 175.
These people have created a hell.
Malad, but
just come to para
but your lordship may also keep one thing in mind with this new STP. Whatever is the deficiency in the full operation of the existing infrastructure, it is going to be augmented by 90 ml.
So when did the Nigam realize that we should have STPs? Till this period of time, the sewage was being discharged in the river.
Latest of respect,
then what were you doing?
Malad, it is recorded. 9 are there before your lordship took cognizance.
I'll read it for your benefit.
The existing STPs are also not meeting the parameters.
Malad, your lordship, no, Malad, the operations, most of the time, Malad, it is not 100%. So, Malad, you always provide for something more.
It's not even 20%, Mr.
No, Malad, that was respect. 170. Against.
I'll read it for your benefit.
I'll read it, Malad.
CPCB report, Central Pollution
Malad.
Control Board report of 5th December 2023 has recorded a categorical finding that no STP after treatment is meeting prescribed parameters. Therefore, the entire treated water is not meeting the parameters and comes within the category of polluted effluent sewage.
Malad,
Now see this figure.
Your lordships are at which page, Malad? And the
page 182.
Malad, if your lordship may kindly, Malad, that's the general for various authorities. Kindly come to the specific authority of Agra, who's the petitioner, which starts at page 107, and the details are given, Malad, at page 109, and kindly see para 186 at page 110 and 111. They are general observation, Malad, direction. Insofar as Agra Nagar Nigam is concerned.
But this is all within Agra Nagar Nigam, right? 338 is all within Agra Nagar Nigam.
Malad, if your lordship may just see
Udika, Nagla, Pilkar.
107, if your lordship may kindly see page 107, where, Malad, at 3 pages up to 112, the Agra Nagar Nigam's, Malad, infrastructure capacity, its function.
Come to 334 again.
Yes, Malad, 334.
This is something very disturbing. Admittedly, STP's installed capacity is 220.75 MLD, while all 9 drains are discharging 286 MLD of sewage in River Yamuna. Therefore, there is a clear gap of 65.25 MLD. That is, what is this figure? 60.
Malad, that must be the million liters, Malad, of
Correct.
Now, Malad,
all this additional untreated goes straight into the river.
This augmentation of this STP, Malad, would create a surplus of 90 MLD.
Which it happens.
Which is too delayed, Malad, because of no fault of ours. And I'm not attributing fault to anybody.
Even the existing STPs were not performing your
Malad, your lordship, no, Malad,
But what we'll do is we will delete those observations in regard to PMLA.
And, Malad, the parameter, the environment parameter, your lordships are deciding, Malad, when the Ministry of Environment notification is in existence.
The specific findings which have been arrived at by the National Green Tribunal in paragraphs 333 to 342 pertaining to Agra city, pertaining to the discharge of untreated effluent in the river Yamuna in relation to Agra city, we are not inclined to entertain the appeal insofar as the imposition of environmental compensation is concerned. However, we find from the impugned order dated 24 April 2024 that the NGT has discussed, namely, criminal liability for offences under the Prevention of Money Laundering Act 2022. Stop. The discussion in that regard is contained in paragraphs 357 to paragraph
385, my lord.
Paragraph 385 of the impugned order. Full stop. After discussing the the NGT has answered issues 4 in OA1 and OA2 in the affirmative, against the respondent, while holding that it is incumbent upon the competent authorities regulating and enforcing PMLA 2002 to take action against such violators. Full stop. The above direction, however, does not find place or in the operative directions contained in paragraph 386. Stop. All that needs to be clarified is that the observations of the NGT with regard to the alleged violation of the PMLA did not appropriately fall for consideration and in any event would not fall within the remit of the tribunal. Full stop. The observations, therefore, shall not operate as a binding direction to be followed against the authorities of the Agra Nagar Nigam. Full stop. Save and except for the above clarification.
Second aspect, if your lordship, just only one paragraph, page E, my lord. The Nitin Deshpande which is relied upon in this very case, my lord, that there is parameter laid down under the act by the Ministry of Environment in 2017, notification is 13/10/17. Page E, my lord, just have a look only for a minute and I'm done. 13/10/17. Nitin Deshpande, my lord, is laying down some parameter above that notification that is pending before your lordship in civil appeal number 5.
Clarification.
Is that question to be decided there, my lord? Your lordship, it should not be taken up, my lord, as if your lordships have decided this matter and that matter comes to an end.
Yes.
Right, great.
This is only in regard to 1 lakh costs, right? This matter. Of rupees 1 lakh, which are lying in deposit with the registry in pursuance of item 6. Item 6.
So my matter is regarding 2 wrong biology questions in NEET UG exams. Delhi.
Ma'am, we cannot now re-evaluate the question papers for NEET UG because that whole process came to an end in our. We had directed that, one question where there were 2 answers which were taken as correct, that should be re-evaluated. Now we can't keep on going into this, and both the courts have come to the conclusion that there was no error. What do you have to say, ma'am?
Sir, I have to say that sir, this decision should be made on rational basis rather than preset. No, if subject experts are not wrong, they must produce reference or proof that they are not wrong, or their new propounded theory which they have given should be recognized in books. Sir, I have given NCERT reference, and as per NCERT book, both those questions are wrong. Sir, with respect to question number 149, NTA subject experts have not submitted even a single reference or proof.
Over, ma'am.
Yes, sir, counseling is over.
Now, how do we interfere at this stage? Because now admissions are complete for this year. All admissions are also over for the MBBS first year course. How do we interfere at this stage now?
Sir, I filed my petition in Delhi High Court in June, but they said their jurisdiction is limited in such matters. And
What was the date of the judgment of the single judge? 1st of August.
yes, sir.
Then the division bench is also 13th of August. Now we are in November. What will happen is that we can't unseat the whole process. You're saying the answers to 2 questions were wrong, right?
No,
That
sir.
is
sir,
one question.
No, sir.
2
sir,
questions, right?
Questions are wrong.
2 questions are wrong. That is 105 and 149.
Sir, 104 and
104 and 149. If you are right, then the entire result of the examination has to be redone. What happens to those students who have been admitted? The admissions are also complete. That's why we can't interfere at this stage. Sorry. Thank you.
Item 7.
Tola it will be governed by a judgment in Tola.
Yeah,
The same order.
Same for 7, 8, 11, 17, 42 to 45.
Right.
41 low tax. 30, 41 is low tax.
38 to
40.
41 is low tax effect. 38, 39, 40, 41, we have to dispose it off with that usual order on low tax.
Only 38 is the service tax method, balance all income tax. Like 8 also. Yes.
Item 9.
Item 9. Yes, Mr. Bagaria. Mr. Bagaria, a notice has been given to you by the the National Anti-Doping Agency.
The problem in the matter is this.
Will not interfere at this stage. You will be given a full
Malad,
opportunity.
may I just make a small point
by
on
the
this?
agency.
Malad, the problem is this, that the problem is this. It's a matter of Indian dualism. The Honorable Delhi High Court has gotten Indian dualism wrong. The proposition which it proposes is that an executive can translate international law into Indian law without going to the legislature if it affects citizen. I am on the point of law that this proposition will set a dangerous precedence, that an executive cannot convert treaty into domestic law.
Challenge the final order. If you succeed on merits, there is nothing else then.
No, but the problem is, my lord, the whole institution is without any law. The entire panel has no statutory backing. So today there is a compulsory arbitration.
But it's not a criminal penalty.
No, it is criminal. There is a 4-year criminal penalty on me.
No, it's not criminal. It's a penalty for not participating for 4 years. But you can challenge it.
No, it bans me from complete sport. The burden of proof is also criminal. The proceeding is criminal in nature, my lords. And it's not arbitrable under Indian law. So today you're sending me into, it's against Perkins, it's against Magan Bhai, it's against Union of India versus Azadi Bachao, it's against all the set precedents.
The High Court ultimately has given liberty in the end that after the proceedings are concluded, you can challenge it on all counts.
No, my lord, the liberty has not been given in that sense because I am before a tribunal which I am saying is unconstitutional. So who is testing me? Today the tribunal cannot exist. It is either compulsory arbitration, which is against Perkins, or it's a tribunal not in accordance with 227. Now, where I am taking grievance with the judgment, my lord, is para 15.
What is it? The tribunal is constituted under an executive notification?
Absolutely. There is no law backing the tribunal. And the executive himself is being challenged. The executive decision is being challenged. He is appointing the tribunal.
Otherwise, it will mean this, that people can go on doping and there'll be absolutely no remedy, and there'll be no consequence on the ground that there is no law in India. Therefore, you cannot penalize a sports person who is otherwise engaging in doping. They're not saying
no, my lord, the law is there. Today, the parliament, so this challenge was made a few years back. In the pendency of it, a law was passed. Now the government has not notified the law on one hand, and on the other hand, it's continuing to apply the old executive power. So the problem is not that there is no law. Parliament has passed a law. The government has the power to notify the law.
Now they are taking action against you under the 2021 rules, is it?
Yes, which is not the law. The law is the statute. So you
But that
take an
law has
action
not been
against me.
enforced. That law has not been enforced as yet.
It's not been notified. So you are against me in an unconstitutional position where there is no law and international law has been translated into domestic law by Executive Act. So that goes against Magan Bhai, that goes against Vishakha. And what the Delhi High Court has done is applied Vishakha. 141 cannot be applied by the Delhi High Court.
Thank you. Yes. Yes.
Item 8, issue notice in item 8.
Hey,
Item 10, my lords.
we are passing the usual order. We have already decided the issue. It will be governed by a judgment in Tola. Item 10.
Item 10, my lords, I appear for the petitioners. Notice may be ordered, Your Honor. My lords, this is only by consent that they have agreed that the matter can continue.
Shriram Panchu. Later on, it's an international commercial arbitration.
Yes, my lords.
We will have to treat that appointment as an appointment by this court.
Yes, my lords.
Substantial proceedings have taken place before Justice
Yes.
Mr. Panchu.
Evidence also is complete on the part of the claimants and of the
Let's hear
respondents.
them. We'll issue notice, returnable Kallo after 3 weeks. That's the permitted in addition.
Obliged.
Yes.
The matter was fully heard on merits. We've been knocked out on maintainability. Now, my lords, your lordships.
Interim judgment, interim order can amount to a judgment if it causes.
That's the point. Your lordships, it happens to be your lordship's judgment in Ashutosh Shrotia, full bench of the Allahabad High Court, which has been followed squarely in our case in another matter, my lords, where this was the termination was complete in the.
When a termination is stayed, it may be a matter of prejudice and therefore it may be a judgment.
It is a judgment also because one.
The classical judgment is Shah Babulal Khimji, Justice Fadlali's
which has been dealt with, my lords, in great detail in Ashutosh Shrotia. But here, my lords, we are being compelled to restart what has already been terminated. My lords, and there is against the chairman, there are.
Currently, I am coming to India, my lord, and I'm taking care of. I'm in digital age, my lord. Whether
but you have to be, if you're running a retail outlet,
let
you have to be
order continue, my lord, and
so
let it section 8 be.
What we'll say do is we'll set aside the interim order, and the section 8 and all can be.
My humble request is that since it is on 8th November.
Section 8, but what happens to the interim order?
Your Lordships to take a larger view of the matter. You can't have two classes of High Court judges with all due respect.
May I say, Lord?
Made such salaries as are specified in the second schedule. Every judge shall be entitled to such allowances and to such rights in respect of leave of absence, please mark, my lords, and pension. Lordships find that word in yes. 2, my lords. Leave of absence and pension as may be from time to time be determined by or under law made by Parliament and until so determined to such allowances and rights as are specified in the second schedule, provided that neither the allowances of judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment.
Yes.
That's two submissions here. One, the constitutional provisions do not contemplate two classes of judges. That is, according to me, an effectuated reading of Articles 216 and 221. Because 221 uses the words pension, so I am using that for all post-retirement benefits, including provident fund. That's how we should give meaning to 221. 221, my lords, your lordships have already seen, literally does not use the word provident fund. But that must be the reading that we imbue into it.
That's one. And second?
Point number one. Point number two, my lords. It's very easy for me to make an argument, my lords, equal pay for equal work. But we're not dealing with ordinary civil services. The easiest argument here would have been, in fact, when my colleagues and I were discussing, we had to pick out all the judgments on equal pay to equal work. The judges who are doing the same work can't be subject to two different kinds of post-retirement benefits. But that's not the point here. The point is, it is a constitutional office.
Constitutional institution.
It's a constitutional institution. So it is not some ordinary technical interpretation of the law or a technical doctrine of equal pay for equal work. I'm not in any way undermining the doctrine of equal pay for equal work, but there must be something larger at play when we are talking about the financial independence and security of judges, High Court judges to begin with. It is a question of office. It's not the person.
Yes.
The Act, was formulated at a time when we had more diverse recruitment sources, including the ICS.
1954.
1954, including the ICS. Your lordships know there have been a history of in this country. We have known judges who were paid much better as High Court judges than Supreme Court judges when they were offered Supreme Court judgeship post the Constitution, because the manner in which salaries were regulated were very, very different in the pre-constitutional stage. So it can't be that, my lords, there are two classes of judges. Ramakrishna Raju and your lordship's judgments post that, those two judgments which are to the point that we can't countenance a position where there are two sets of judges. The only other argument which I wanted to draw your lordship's attention to, because if this is the reading that is given, we have copies of the Supreme Court. Supreme Court Judges Salaries Act.
112. Yes, okay. 112(3)(d).
Section 20 may be noted, my lords, of the Supreme Court Judges Salaries and Conditions of Service Act 1958. Plus, it's on your lordship's screen. Plus, every judge, it is impari materia with the other provision.
Yes.
Why I'm drawing your lordship's attention to is because suppose the district judge makes it to the High Court, becomes a Chief Justice, comes to this court also. If the interpretation is to be countenanced, same.
It will be governed by the Provident Fund.
So, would your lordships countenance a situation where there are 25 or 28 different kinds of Provident Fund for High Court judges? High Court today it is actually happening, because if this interpretation is taken in Maharashtra and Karnataka by virtue of judicial orders, there is no longer old pension scheme. It is a new, no longer the new pension scheme. Although the state government slipped into the new pension scheme, judges are still governed under the old pension scheme. So, a district judge elevated in Tamil Nadu will not be entitled to Provident Fund. Elevated to the High Court in Tamil Nadu will not be entitled to Provident Fund. A district judge elevated in the High Court of Bombay will be entitled to Provident Fund. A district judge elevated to the High Court in Tamil Nadu will not be entitled to fixed pension, but a district judge elevated to the High Court in Maharashtra will be entitled to fixed pension. That surely can't be. I don't think there can be 29 varieties of post-retirement benefits for High Court judges under the Constitution as a class. This is a brief summary. On this, once the reply is given by the learned AG on this comment, then we'll take up Mr. Dwivedi's matter. It's slightly different. That's a post-retirement matter, which I think is fairly.
What we do is that because we are closing on 4 o'clock, we're continuing with this matter, and we'll continue first thing on board tomorrow morning. Because this will not be able to hear everybody today. So this will be first on board because we'll deal with this batch. Yes, Mr. Attorney, what do you have to say?
I put in a note on
this. Where is your note, Mr. Attorney?
May I just
we have put in a note in response to this.
Just 3 statements.
Sorry?
May I just add to what Mr. Parmeshwar has
said? In that matter, right?
That matter.
Oh.
Lord, when the Constitution creates a institution, constitutional institution, and a class of judges, then it is not permissible, my lord, to the Parliament or any delegated authority to classify a resort to Article 14, because that class is created by the Constitution itself. So they can't say that to one section of judges will do this and to the section of judges will do that. So it's not permissible. Article 14 cannot be invoked, and this is important because I'm sure the respondents will say that 221 refers to law being made by Parliament. Such salary as may be made by law. If your Lordship looks at 221(1), and similar expression is found in 221(2). So while making the law, it is not permissible to Parliament to differentiate on any ground whatsoever. It has to be, whatever they prescribe has to be prescribed across the board for all the honorable judges. So by Parliament, by law, would not enable Parliament to differentiate or make a class or resort to many classifications. The second is, my lords, a close reading of 221(1) indicates that the domain of lawmaking by Parliament is limited to determining the salary, such salaries as may be determined by Parliament by law. So the scope of lawmaking under 221 is limited to determining what salary, what pension.
But not two salaries.
But not differentiating that one for one section, another for another section. It's only the quantum or the formula for calculating the quantum. The third feature is the proviso in 221, after 221(2), which is also pertinent as it indicates that ordinarily not everything has to be identical, equal. But where somebody is drawing a pension which is higher, then it will not be to his disadvantage. Sometimes it happens that the district judge may, because of his long service, may, when he is elevated, be getting a pension which is higher. That can't be varied to his disadvantage. So he gets the advantage of coming in the same class, to get the same salary, to get the same pension, same provident fund, same post-retirement benefits. So what has been taken care of by the framers of the Constitution is that the proviso has been put in that you can't vary to his disadvantage. The advantage is there of being in the same class, but he can't be varied to us. So the idea of equation is also indicated by this. These are the three things we have.
There's one more provision which the learned Attorney General relies heavily on in his notice, section 15 of the Act.
15 of the Act.
15 of the Act, which your Lordships will find at page 15 of this note. Because here election comes into place. Special provision of pension in respect of judges who are members of a service. Every judge who has held any other pensionable post under the union or a state shall, on his retirement, be paid a pension in accordance with the scale and provisions in Part 3 of the first schedule, provided that every judge shall elect to receive pension payable to him either under Part 1 of the first schedule or Part 3 of the first schedule, and the pension payable to him shall be calculated accordingly. So they say if there is an election, the emphasis in section 15 in the note of the Attorney General is that once you have elected to get it under this or that, then you are governed by that. Either first part or the second part, there's no question of being governed by a more beneficial provision is the emphasis that is being. But your Lordships will note section 15 has to do only with pension. So far as section 20 Provident Fund is concerned, my lords, there is no question of election. So I can understand if there was some sort of election in 20, there's no question of election in 20. provident fund, either you get it or you don't get it. Today, what they are saying is you don't get it because the state pensionable service did not have a provision for provident fund in the respective state. Even in 15, my lords, your lordships have your lordships, Punjab and Haryana High Court, what's that called? Rajrani. Even there, your lordships have now sort of varied the provision and said, doesn't matter what is the source of recruitment, whether there's a break of service or not. Just like your lordships gave the members of the bar 10 years from the bar as additional years of service so that they are entitled to pension. Your lordships knows that in that judgment, your lordships have quoted all those judgments. District judges, when they are members of the bar who are elevated to the High Court but only get 4 or 5 years of service, do not get pensionable service. So your lordship said add 10 years practice from the bar, make them entitled to a pensionable service so that they are qualified for pension under the Judges Salaries Act. Similarly, my lords, it can't be, when your lordships have done that for judges who have come from the bar, it can't be that judges from the district judiciary are worse off, either for pension or for provident fund. In any event, my lords, as I said, this act is a very old piece of legislation. It predates multiple pension schemes in the country. To have some effect to this, the argument is that there are homogeneously one constitutional class.
And if Lordship may see, Article 112, Clause 3D, Clause 3, Subclause 3, Lordship may see, the pension of a High Court judges, my lord, have been put in a higher pedestal, my lord, than the salary of the High Court judges, my lord. The salary of the High Court judges, my lord, is paid from the consulate fund of the state, my lord. Per contra, my lord, Lordship may see Article 112, Subclause 3D, Subclause 3, my lord. The 112, my lord. Article 3, Clause D, Subclause 3, my lord. The pensions, merit, my lord. Article 112, my lord.
Yes.
3D, Subclause 3. The pension payable to or in respect of the judges of any High Court which exercises jurisdiction in relation to any area included in the territory of India, or which may at any time before the commencement of this Constitution exercise jurisdiction in relation to any area included in a government province. This says, my lord, that the following subclause 3, my lord, the following expenditure shall be expenditure charged on the Constituent Fund of India. So, my lord, my argument is also this, my lord, that the new contributory pension scheme is, my lord, only applicable to those who are the employees of the state government, my lord. My lord, Pratibha Banerjee's case, my lord, this Honorable Court has clearly held that the judges are not, my lord, the employees of any central government or the state government, my lord. And therefore, my lord, if that scheme is said to be applicable to us, my lord, then how we will get a pension, my lord, under Article 112, my lord? Subclause. Lordship may see Article 112, Sub-Article 3, Clause 3. The following expenditures are expenditure charged on the Constituent Fund of India. Are we further on tomorrow, my lord? My lord, the second issue, my lord, for a second, my lord, page 63, my lord.
Page
63 of my lord, writ petition number 232.
Just tell us what it is.
The same, my lord, the Undersecretary, my lord, which has who has issued the letter, letters, has also issued this letter. Reply, my lord. High Court judges elevated from judicial service can opt to receive pension under Part 1 of the first schedule of the Act 1954. Under Part 1, a retiring judge is paid a pension of Rs 96524 per annum for each completed year of service as High Court judge. However, only the service rendered as a High Court judge is counted for the pension under Part 1. The service rendered as judicial officer shall not be counted for the purpose of calculation of pension, my lord. The repercussion of this is this, my lord, that now by interpreting the law in this way, in the respect of the judges of the Allahabad High Court, my lord, I have filed writ petition on behalf of Justice Vikas Kumar Srivastava he's getting pension of rupees 11,253. That's why, my lord, in Raj Rahul's case, my lord, the girl's case, my lord, my lord said that there cannot be any difference, my lord, between two sets of judges, my lord. Therefore, my lord, the length of service, 10 years of service, my lord, which is applicable for those who are eligible for the bar, is also to be counted for these judges, my lord. Because there is also a prayer for this, my lord. Because now, if they interpret this way, my lord, we will get pension of 11,000 only, my lord.
So the district judges who are appointed, they should also get the addition according to you of 10 years.
Yes, my lord. Their length of service they have rendered, my lord, should also be counted as a high court judge, my lord. That will be clubbed, my lord. And in fact, my lord, in Justice S.L. Saxena's case, this honorable court has clearly held that once the district judge is appointed, elevated as a high court judge, the service of a district judge, my lord, is to the high court judge is continuing, my lord. I will show that judgment. I have brought the judgment, Lord. Tomorrow I will show the judgment, Lord.
Like we continue tomorrow morning.
I will show it, Lord.
The rest of the board will continue tomorrow. Rest of the board, what we'll do is we'll continue tomorrow, because we were in 2 or 3 heavy matters today, but we have a board, so we'll at least call out this board and then take tomorrow's board.
Allah, I have 3 or 4 submissions, my lord.
We'll hear it tomorrow. Who are you appearing for?
I am appearing for Justice Ajit Singh, my lord. Bill number 23.
23. You have that?
Next set of matters.
Next set of matters. That we'll complete this set of matters first and then go to the next. So that we'll complete this, dictate a judgment in the court, then go to the next.
It is interlinked, my lord. I am supporting him.
Because we don't have the luxury of time. We'll
take
get the judgment.
Nothing more.
Minutes, item 25 minutes.
I have only take 5 minutes on that.
That's to continue tomorrow. Item 25 minutes. That's to continue tomorrow. My IA needs to be listed minutes. I'll give the details minutes.
I will be part of the brief.
It's not been listed today minutes.
IAs are listed.
Only some have been listed.
IAs which are mentioned are listed.
Oh, I see.
Not the other ones.
Bihar Cricket Association.
We'll give the list.
Just
Just
item
item. We'll give the list.
46 to be taken up tomorrow. Well, item
Yeah, we just said that all the board will be taken.
Speak up.
So,